Hello, and welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan, where I've been practicing law for 24 years in the fields of consumer protection and lemon law. I frequently write about this stuff for places like Jalopnik and Opposite Lock, and I've written a few books and magazine articles as well. I've represented thousands of people who bought thousands of defective cars, usually one at a time, and I often hear crazy excuses made by sellers as to why my clients have got no case. And it's not that the car's not defective, it's always something else, or seemingly so. So today's top excuse is used by sellers of defective cars. My favorite, of course, is buyer's remorse. A client buys a $75,000 SUV and the engine explodes a few too many times. They file a lawsuit, and the defense attorney calls me up and says, Steve, your client's not really upset about the exploding engine or the failing transmission or whatever else is wrong with the vehicle. They're simply embarrassed that they spent so much money on a vehicle they couldn't afford, and they bit off more than they can chew, and they're suffering from buyer's remorse. And I always say, well, if I bought a $75,000 vehicle and the engine exploded, I'd be upset about the engine exploding. Call me crazy. And they say, no, your client just spent too much money and now they're ashamed of themselves. So they try to blame the victim. And my favorite example of this actually is a boat case. And I realize that boats aren't cars, but I deal with a lot of big ticket items. And I had a client who bought a boat, took it out on the lake, and every time he took it out, it would start bringing water into the boat. It was leaking. And he'd take it back to the dock, bring it back to the dealership. They'd say, we'll look at it. They work on it. They say, yeah, it's fixed. One occasion, they sent it back to factory and said it was fixed. And every time he brought it back to the lake, put it in the water, it starts bringing in water. We file a lawsuit for breach of warranty. Call me crazy, but I think a leaking boat is doing something wrong. I mean, different minds, I suppose, might differ on that, but I don't think so. So we filed a lawsuit, and the defense attorney calls me up and says, Steve, your client's not upset about the boat taking on water. He's scared of how fast the boat is. And I said, what? He's a guy. He bought a boat. You think it's too fast? It's like telling a guy his Ferrari is too red. And he goes, yeah. He went out on the boat one time with somebody from the dealership, and they thought he looked like he was scared of how fast the boat was going. We think he's simply trying to get rid of the boat because he's scared of it. And I said, yes, he is scared of it. He's scared it's going to drown him one day and put him at the bottom of the lake. And the attorney said, no, he's scared of it because it's too fast. Well, that didn't go much farther than that. In fact, I never even heard the argument again. But again, a lot of attorneys will raise arguments on the phone that they won't make in court. That's too bad, because I'd like to argue some of these cases in court. It'd be kind of fun to get in front of the jury and say, yeah, they think my client bought a boat and it's scaring him, but not for the reason you think. Second big excuse I often hear is they'll say there's simply nothing wrong with your car. And I've had people with cars that have got serious problems. They leak, they pull to one side, and the dealership says, yeah, we'll work on it. They keep working on it. They can't fix it. We filed the lawsuit under the lemon law, and the manufacturer says, well, what you're complaining about is not really a defect. It's not really a defect. My favorite example is I had several dozen of these cars back in the early 90s from one particular manufacturer that all pulled to one side. And there was something wrong with the design of the front ends on these cars. I don't know what it was. Someday I'll talk to an engineer from that company and find out, but for about 5 years, I got numerous vehicles in my office with a problem where they all pulled to one side. And what would happen is I'd file the lawsuit, and the manufacturer would defend it and say there's nothing wrong with the car. So I'd have to take the deposition of somebody from the factory or from the manufacturer and say, what's your explanation for why the car pulls to one side? And he goes, it's the crown of the road. Now roads are crowned in some places, especially out in the country. You're driving along the road, and the road is crowned. It's curved towards the side to make water run off to the side of the road. But not all roads are crowned. And in fact, these cars would pull to one side when driven on a flat parking lot. And I would say that to the guy, and he'd say, well, parking lots are crowned also. And I said, but not all roads are crowned to the right. So for instance, you're driving down, like say, Woodward Avenue, which is 4 lanes each direction in some spots. And as you get towards the inner lanes, it crowns the other way. And he said, well, it would pull that way then. And I said, no, it doesn't. That's the thing, is these cars all pull to one side. And when you take it to the dealership, they then try to realign it to compensate and make it pull the other way. And the most they can ever do is get it close. But they can never make it go the other way. And I said, but why are all these cars pulling to the same side? And the guy goes, because it's the crown of the road. And the guy would sit there with a completely serious look on his face, swearing this under oath, penalty of perjury and all that, and he says, yes, there's nothing wrong with your client's car, it's the crown of the road. Now, preceding this, my client had brought the vehicle into the shop 4 times, and the manufacturer had paid for the repairs, and not once did a technician or a mechanic say, there's nothing wrong with this car, it's the crown of the road. And I'd say, by the way, why don't all your cars do this? And he said, they do. They all pull this way. And I said, how come I keep filing these lawsuits for the same model car? It's not the other cars, okay? Yeah, and I know for a fact that other cars of theirs didn't do this. It was something to do with the suspension or the front ends in these cars. And the guy said, nope, they all pull like this. There's nothing wrong with your client's car. It's just a coincidence you keep filing these same cases for the same cars with the same complaint. And he goes, it's simply because the roads are crowned and it's the crown of the road. There's nothing wrong with the car. And it's an insane argument, but that's what the guy argued. So we would still win those cases, but that was the argument they'd make before they lost. Now, there's another argument that defendants will often make, and it's not quite like saying there's nothing wrong with your car, but they say, hey, it's still under warranty, keep bringing it back in. And I've had defendants say there's nothing wrong with a vehicle because if you bring it in, we'll work on it. Simply keep working on the vehicle, and there's nothing wrong with it. And I've told the story before about my client who brought his car in 35 times for the fact that it had a water leak. And this is all under warranty. Every time he'd bring it back in, they'd say, oh, it's you again. And they'd work on his car, and they'd give it back, and it wasn't fixed. And when he came into my office at 35 repair attempts, and I jokingly said, why didn't you come in at 31 repair attempts ago? He said, well, they keep working on my car and they seem nice, you know. And one time he stopped by my office in a heavy rainstorm and said, come on out and look at my car. And he opens the door to his car, and of course his car's got 4 inches of standing water in the passenger compartment. And this is a car, it's not an SUV, it's a car. And he says, you know, so I had to drive here, and that's when I realized his shoes are soaked. His feet are soaked past the ankle. He's driving around with 4 inches of standing water in his car. And yet the manufacturer just says, well, he can keep bringing it back in. As long as he brings it back in, we'll work on it. It's still under warranty. What's he complaining about? I said, well, the Lemon Law says you get 4 repair attempts. If you can't fix it in 4, you're done. No, keep bringing it back in. Years ago, a couple manufacturers in Michigan used to use the Better Business Bureau auto line arbitration process in an attempt to settle cases before people filed lawsuits. And I had clients who went through that process before filing a lawsuit. And we found out later that these manufacturers had written their own rules and controlled the process so they could actually control the outcome. And I had clients who bought defective cars. They were in the shop more than enough times to qualify, and they thought, you know, I'll try this auto line thing through the BBB, not knowing it's a scam. And so they go through the process, and the arbitrator drives the car, sees the problem, sees the last chance letter, sees all the repair orders, and says, yep, you've got a winner here. You've got a winner under the Lemon Law. I will send you your award. You've won. And then the client gets a thing in the mail. It says, it is the arbitrator's decision that you win. You are awarded another repair attempt. Never mind the fact that repair attempts are free under the warranty and these vehicles are still under warranty. They say keep bringing it back in because the warranty is still there. And as long as you get free repairs, you've got nothing to complain about. At least that's their argument. It's not a good argument, and it's not a legal argument because the Lemon Law says there does come a time when you can say enough is enough. One problem I often hear about, one excuse I often hear about, is where the dealership and the manufacturer blame each other. It's not our fault, it's their fault. This is extremely common when someone gets to their wits' end and they start screaming and yelling in the service department about why can't you fix my car after 5 or 10 repair attempts. And the dealership personnel will pull the customer aside and say, well, this is a problem the manufacturer knows about, and they simply don't know how to fix it. So they tell us to do this, that, and the other thing, and we know it's not going to fix it, but we do it. And they pay for those repairs, but it's not going to fix it. We're simply waiting for a technical service bulletin or we're waiting for a recall. And I've had so many clients tell me that they've been told, yes, we're waiting for a fix. We're waiting for a fix. Well, waiting for a fix doesn't fix the car. And so when I hear that, I say, well, make sure they write it up. And I've had people say, well, I went in. They said, well, we can't fix it. We won't give you a repair order. But if you bring your vehicle in and complain of a defect and they can't fix it, whether they refuse to fix it or refuse to work on it or say they're waiting for a fix, you get a repair order, and that counts as a repair attempt, even if they didn't take it. But they can't blame each other. Sometimes the manufacturer, though, will blame the dealership, and for good reason, I can tell you. In the early 1990s, about 1/3 or 1/4 of all the cases in my office were coming out of one dealership in Michigan. Every Lemon Law attorney watching or listening to this podcast knows who I'm talking about. And this dealership was a high-volume dealer. They did tons of business, and they created lots of lemons. And you might say, wait, Steve, what do you mean by the dealership creates lemons? Well, the cars get built at the factory, and then they get shipped to dealerships who sell them, and then the dealerships do the repairs on them. And a bad service department failing to repair a vehicle after a certain number of repair attempts will, in fact, create a lemon. And that's what happened. This one particular dealership was so bad at doing repairs that they couldn't fix things when other dealerships could. And the reason I know this is that after a few years, suddenly it dried up. this dealership fell off my radar. I got very few cases from it ever again. And so one day I was talking to the attorney from that manufacturer and I said, I'm curious, why is it I no longer get that many cases from this dealership anymore? And he said, oh, they hired a new service manager. They fired the old guy. And it turns out that under the new service manager's regime, they could actually fix cars. And they were fixing cars and they were not creating lemons. So in that particular instance, the manufacturer was right to blame the dealer because the dealership was in essence creating lemons by failing to fix the cars. And then when we sent the last chance letters to Ford, they weren't sure exactly whether it was their fault or the dealership's fault, and they usually would skip the last chance repair, and they wound up buying back tons of cars on behalf of that one dealer. Now, another problem I often hear used as an excuse by a seller of a defective car pops up when people do title skipping or curb stoning. You buy a vehicle from an individual and you've got some kind of problem with it, you go back to talk to that guy or girl, and she says to you, oh, I wasn't selling it to you on my behalf, I was selling it to you for somebody else. Now, I've talked about curb stoning before, and this is one of the problems, is that curb stoning is a couple different transactions fall under the umbrella of that term. Curb stoning is where you show up at a private residence and you're looking at a car and the seller then says, oh, by the way, we're going to do the paperwork over at my friend's dealership because it'll save us some time on the paperwork. And in reality, he's selling cars off the lot at a different location. And then sometimes curb stoning refers to the fact that someone's selling a car in their front yard and they're talking to you and it turns out they're selling someone else's car. And this is also pops up with title skipping. Okay, so I buy a car from somebody and they fill my name in to show that I'm the buyer and they're the seller. And then we take that title to the Secretary of State's office and get it put into my name. That's the proper transaction. A title skipper takes the title from the seller but never fills in their own information as the buyer. And then they take the car and they sell it to somebody else and they put that person's name in as the buyer, so that when they go to the Secretary of State's office, it looks like the end buyer bought it from the original seller and the guy in the middle doesn't show up at all. So what happens is, I've had this happen for a variety of reasons, where someone goes back to complain to the guy they bought the car from about one thing or another, often problems with the title, and the person says, well, I'm sorry, I'm not the one who's selling you the car. You bought the car from somebody else that you never met. And that, of course, is one of the reasons I urge you to avoid curb stoners and title skippers, because you can have these problems. I had a case once where a client bought a car, guy skipped the title to him, he didn't quite figure out what was going on until it was too late, and when he got to the Secretary of State's office, they said, well, there's a problem with the title, you've got to get the seller to sign an affidavit that this mistake here is actually correct. And so my client calls the guy he bought the car from, the guy goes, that's not me, that's not me, that's somebody else, that's somebody in Wisconsin. So my client does the research and finds out that the person's name on the title is a dead person. Person died. And the guy he bought the car from had apparently bought it from the estate, and it became a mess. It was a big, big mess. So you have to always wonder if the person you're buying the car from corresponds with the name on the title. And if it doesn't, you might have problems, because that person very well could say to you one day, you didn't buy the car from me, you bought it from somebody else. And for those of you who are really fascinated by legal nuances, of course, you're buying the car from the person who's standing there talking to you. But legally, paperwork-wise, is a whole different thing, and straightening that out could be a mess. So when somebody says to you, you didn't buy it from me, you bought it from somebody else, that's another thing I often hear about people, from people who sold defective cars or problems with the title, the defective title. Finally, the top excuse used by sellers of defective cars, and this is probably the top excuse of all time, is simply, we sold it to you as is. And a lot of car sellers think that that's like a magic get out of jail free card, when in reality it's got a very narrow meaning under the law. Buying a vehicle as is means it comes with no implied warranty of merchantability, and all cars sold by individuals are presumed to be as is in most states. But it doesn't protect you from everything. Now, it does protect the seller from from selling a piece of junk. Okay, so you go and look at a car, you drive it, seems okay, you buy it, engine explodes the next day. You might not have a case against that person if they didn't know there's anything wrong with the car. So the idea that there's something you can do as is does eliminate a lot of that stuff. But I've sued somebody before who spun the odometer back. You know, odometer tampering. Odometer tampering is a violation of a federal statute and a state statute in Michigan and in most states. It's a crime. You can go to jail for odometer tampering. Now, no one ever does, but you could. You could go to jail for it. Once in a while, you hear about somebody who's involved in an odometer tampering ring where they're doing it many, many times, and the feds get tired and finally say, fine, let's throw this person in jail. And I've actually sued somebody who spun the odometer back on a motorcycle, on a car, I sue them, and they come back and their attorney says, hey, we sold it to you as is. And there's a long pause on my end of the line as I'm thinking to myself, an attorney just said that to me. That's funny. And I say, so your argument is that an as-is sale bars a claim for odometer tampering. And I've had, I'm guessing, half a dozen attorneys say yes. And I say, can you show that to me, please, in the law books? And see, this is something I talk about often on this show, is that behind me, if you're watching the video, those blue books right there are law books. All of the laws of the state of Michigan are contained in those blue books. And if it's a law, it's in those books. And I say, what's the citation of the law that says that as is bars a claim for odometer tampering? And they say, well, no, it's just as is. As is, that's what as is means. And they actually get back to this, what the street meaning of as is. And I said, well, you know, as is defined in the Uniform Commercial Code, which is found at MCL 440.231, et cetera, et cetera. And I say, show it to me in there. And if they look it up, they see that as is simply means no implied warranty of merchantability. Does not mean that you can commit crimes, doesn't mean you can commit fraud, doesn't mean you can commit misrepresentation. There's all kinds of things you can't do. And I like to blow people's minds by saying, and it doesn't mean you can breach an express warranty either. And people say, well, what do you mean? How would you have an express warranty when you disclaim the implied warranties? It's easy. And it's, you know, like the year and make and model of the car, for instance. You know, if I advertise I'm going to sell you a 1965 Mustang, and you buy it and it turns out to be a 66, which is worth less money, you could sue me for breach of warranty. And the warranty is the year of the car. I'm not making this stuff up. Go look it up. I'm right. So I have to tell attorneys, no, you can't spin the odometer back in a car and sell it as is. If you could, everyone would do it. So those are the top excuses used by sellers of defective cars. You're suffering buyer's remorse. There's nothing wrong with the car. You can keep bringing it back in so that you've suffered no harm. It's someone else's fault. I didn't sell you the car, someone else did, or we sold it to you as is. Those are the top excuses used by sellers of defective cars. Questions or comments, as always, contact me at lehtoslaw.com, LEHTOSLAW.com. I'm on Twitter at Steve Lehto, at STEVELEHTO. And this show's on iTunes, Stitcher, SoundCloud, and YouTube. Please rate it, and thanks for listening and watching. Bye-bye.